Welcome to Legal Minds. The first thing you need to realize is that the term assault is a very general term. It's also known as common assault, and it refers to either what's known as a technical assault or a battery. In this presentation, we are only concerned with the former, a technical assault. This type of assault was defined in the case of Fagan. It will be committed where the defendant intentionally or recklessly causes the victim to apprehend unlawful immediate violence, and this definition was also confirmed in the case of Ireland. So the actus reus of assault is the causing of apprehension of unlawful immediate violence upon the victim. But what sort of conduct will actually amount to an assault? Well, throwing a feint, for example, will amount to an assault. So where you pretend you are going to punch somebody, that is sufficient. Verbal threats are enough, gestures enough, shouting, charging towards somebody is enough. In the case of Ireland, it was said that an assault might be committed by words or gestures alone. So in other words, you don't actually have to apply force. If you do apply force, it will be another offence, but that's another topic. It could be a battery, it could be Section 47. It really depends on the outcome. In the case of Crown against Ireland, silent phone calls were sufficient. The defendant in that case persistently rang the victim but remained silent, so that all the victim could hear was heavy breathing. Now, even though he was silent, that was sufficient, that amounted to an assault. So in some circumstances, even silence could amount to an assault. And in the case of Constanza, the defendant sent 800 threatening letters to the victim, and that was sufficient. This case may be distinguished from cases where a defendant doesn't send 800 threatening letters, but maybe sends one letter. Maybe then you could argue that assault hasn't taken place, but it's highly unlikely the court will come to that conclusion where all the elements of an assault have been met. And there must also be an apprehension. In the case of Lamb, it was said that there must be a real apprehension. So the defendant in this case threatened the victim with a gun, but the victim didn't apprehend because he thought it was part of a practical joke. Therefore, there was no apprehension, no assault had taken place. However, this is to be contrasted with cases such as Logden and DPP. In this case, the defendant pointed a fake gun at the victim. The victim didn't know it was a fake gun, so the victim didn't apprehend violence. The victim did apprehend violence, despite the fact that it was a fake gun, because he thought it was real. And because he thought the gun was real, there was a real apprehension. So therefore, an assault had taken place, despite the fact that the defendant was using a fake gun. And in the case of Ireland, it was said that violence does not have to be certain. The expectation of violence is sufficient for an apprehension. Lastly, in the case of Smith and Superintendent of Woking Station, the court distinguished between two situations. The first being where a defendant shakes his fist at the victim who is safely locked in his car. In this situation, there will be no assault, according to the court, because there will be no apprehension. Personally, I disagree with that view. I believe that if you are locked in your car and somebody is shaking their fist at you while you're locked in, I still believe there's a possibility to apprehend violence. Just simply because you are still somewhat proximate. If they're near the window, there is that possibility still. But the second situation they referred to is essentially what happened in the case of Smith and Superintendent of Woking Station. The defendant actually looked through the window of the victim's house late at night. In this kind of situation, it was accepted that the victim would have no idea what the defendant would do next, but that what they feared would be something of a violent nature, and therefore an assault could be committed. I shall now pass you over to my fellow law student, Denzel Clark, who is going to cover the element of immediacy and mens rea for the remaining part of this video.
Thank you so much, Dominic, for the introduction. So on the topic of immediacy, immediate connotes instant, but that's not actually the case in law. Its meaning over the last couple of years has been stretched quite significantly, and this is demonstrated in the case of Constanza, when it says a fear of violence, not excluding the immediate future, was sufficient. However, in the case of Ireland, Lord Stein said that immediate meant imminent. There are still limits, of course. If you say to somebody, next week I'm going to beat you up, that will not amount to an assault. In Ex parte Sedatum, it was said, immediate does not mean instant. It connotes proximity in time and space, and that violence will come in relatively short periods of time. So there must be proximity in time and space. This goes back to Dominic's earlier example of being threatened by somebody across the globe. However, where it is unclear when violence will occur, as with the case of Constanza, there can still be an assault depending on the facts of the case and the circumstances. So another case of Smith and Superintendent of Woking Station. A man peered through the windows of a victim's house at night. Violence could not be carried out immediately, but the court said she did not know what the defendant was going to do next, but that wherever it was sufficiently immediate as something of a violent nature. So in very particular scenarios, words could actually negate an assault. This has been demonstrated in the case of Tuberville and Savage, where one individual was heard saying, "If it was not for a size time, I would draw off my sword." However, this must be distinguished from conditional assault, such as, "Watch after school, fam." For the mens rea of an assault, there must be intention or recklessness as to causing the victim to apprehend unlawful violence.